Magandang araw po sa inyong lahat at welcome po sa isa na namang video ng Payo ng Abogado. Para sa module na ito, ang pag-uusapan po natin ay circumstances which mitigate criminal liability. Simulan na po natin. Mitigating circumstance definition. A mitigating circumstance is a circumstance, situation, or incident that attended before, during, or after the crime is committed, which will mitigate, lessen, or reduce the penalty to be imposed by the court because of the presence of the said circumstance. What are the kinds of mitigating circumstance? Number 1. Ordinary mitigating circumstance. If it is present in the commission of the crime, the penalty to be imposed should be on the minimum period of the penalty for the crime committed. Example, Tigas killed Daga. Tigas, of legal age, was found guilty of the crime of homicide, but Tigas voluntarily surrendered to the authorities. Hence, the penalty of reclusion temporal for the crime of homicide shall be imposed in its minimum period because of the said mitigating circumstance of voluntary surrender. If no mitigating circumstance and no aggravating circumstance, the penalty to be imposed is on the medium period. Number 2. Privileged mitigating circumstance. If it is present, the penalty to be imposed should be lowered by 1 degree from the penalty for the crime committed. Example, Kulit killed Yabang. Kulit was a minor, 16 years old, at the time he killed Yabang. Kulit is determined to kill Yabang because he does not like Mayabang. Kulit was found to have acted with discernment in killing Yabang and was adjudged guilty of homicide. The penalty for homicide is reclusion temporal, but because of minority, privileged mitigating, the maximum penalty to be imposed should be lowered by 1 degree, from reclusion temporal to prisión mayor. Prisión mayor, in its medium period, would be the penalty as the maximum. The maximum penalty is within the range of prisión correccional because the indeterminate sentence law should be applied by the court. Number 3. That the offender had no intention to commit so grave a wrong as that committed. Number 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Number 5. That the act was committed in the immediate vindication of a grave offense to the one committing a felony or delito, his spouse, ascendants, or relatives by affinity within the same degrees. Number 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8. That the offender is deaf and dumb, blind, or otherwise suffering from physical defect, which thus restricts his means of action, defense, or communications with his fellow beings. Number 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of the consciousness of his acts. Number 10. And finally, any other circumstances of a similar nature and analogous to those above mentioned. To illustrate, in a particular case, there is the privileged mitigating circumstance of minority and 2 ordinary mitigating circumstances, voluntary surrender and immediate vindication of a grave offense. Because of the presence of the privileged mitigating circumstance of minority, the penalty of reclusion temporal for the crime of homicide should be reduced by 1 degree to prisión mayor, pursuant to Article 68 of the Revised Penal Code. The penalty of prisión mayor should further be reduced to prisión correccional because of the presence of two ordinary mitigating circumstances without any aggravating circumstance, pursuant to Article 64, Paragraph 5 of the same code. Let us examine sample cases. Number 1. Those mentioned in the preceding chapter when all the requisites necessary to justify or to exempt from criminal liability in the respective cases are not attended. This number 1 speaks of incomplete justifying or incomplete exempting. Incomplete self-defense is not considered as a justifying act, but merely a mitigating circumstance. Hence, the burden of proving the crime charged in the information is not shifted to the accused. In order that it may be successfully appreciated, however, it is necessary that a majority of the requirements of self-defense be present, particularly the requisite of unlawful aggression on the part of the victim. Unlawful aggression by itself or in combination with either of the other two requisites suffices to establish incomplete self-defense. Absent the unlawful aggression, there can never be self-defense, complete or incomplete, because if there is nothing to prevent or repel the other two requisites of defense, will have no basis. Number 2, that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. This number 2 speaks of minority, privileged mitigating, an old person over 70 years old. Thus, the imposable penalty for the crime of rape with homicide is death. Under Article 63 of the Revised Penal Code, if the penalty prescribed by law is composed of two indivisible penalties, the lesser penalty shall be imposed if neither mitigating nor aggravating circumstances are present in the commission of the crime. Absent any aggravating circumstances, the lesser penalty of reclusion perpetua is imposable. Furthermore, since accused appellant was a minor when he committed the crime, he is entitled to the privileged mitigating circumstance of minority under Section 68(2) of the Revised Penal Code. Thus, the proper imposable penalty on him is reclusion temporal. Because of minority, the penalty of reclusion perpetua was reduced to reclusion temporal. Minor offender is now called Children in Conflict with the Law, CICL, pursuant to RA number 9344, otherwise known as the Juvenile Justice and Welfare Act of 2006. Coming now to the proper penalty to be imposed, Article 249 of the Revised Penal Code provides that the penalty for homicide is reclusion temporal. The special mitigating circumstance that the offender is more than 70 years old having been established in this case, the penalty of reclusion temporal ought to be imposed in its minimum period. Applying the indeterminate sentence law, appellant could only be penalized with an indeterminate penalty ranging from 6 years and 1 day of prisión mayor as minimum to 12 years and 1 day of reclusion temporal as maximum. Number 3, that the offender had no intention to commit so grave a wrong as that committed. The Revised Penal Code provides under Article 13(3) the mitigating circumstance that the offender had no intention to commit so grave a wrong as that committed. We held this mitigating circumstance addresses itself to the intention of the offender at the particular moment when the offender executes or commits the criminal act. We also held this mitigating circumstance is obtaining when there is a notable disparity between the means employed by the accused to commit a wrong and the resulting crime committed. The intention of the accused at the time of the commission of the crime is manifested from the weapon used, the mode of attack employed, and the injury sustained by the victim. The mitigating circumstance that the offender had no intention to commit so grave a wrong as that committed should also be appreciated in favor of petitioner. The frantic exclamations of petitioner Navarro after the scuffle that it was Lingan who provoked him shows that he had no intent to kill the latter. Thus, This mitigating circumstance should be taken into account in determining the penalty that should be imposed on Petitioner Navarro. The allowance of this mitigating circumstance is consistent with the rule that criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended. Here are the facts of this Navarro case. Lingan intervened and said to Petitioner Navarro, "Huwag namang ganyan, pumarito kami para magpa-plotter. I am here to mediate." Petitioner Navarro replied, "Walang press-press, magsampu pa kayo." He then turned to Sergeant Año and told him to make off record the behavior of Halbuena and Lingan. This angered Lingan, who said, "Oh, di ilagay mo dyan." Petitioner Navarro retorted, "Talagang ilalagay ko." The two then had a heated exchange. Finally, Lingan said, "Masyado kang abusado, alisin mo yung baril mo at magsuntukan na lang tayo." Petitioner Navarro replied, "Ganon." As Lingan was about to turn away, Petitioner Navarro hit him with the handle of the pistol above the left eyebrow. Lingan fell on the floor, blood flowing down his face. He tried to get up, but Petitioner Navarro gave him a fist blow on the forehead, which floored him. Number 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Provocation is defined to be any unjust or improper conduct or act of the offended party capable of exciting, inciting, or irritating anyone. In order to be mitigating, provocation must be sufficient and should immediately precede the act. Provocation is sufficient if it is adequate to excite a person to commit the wrong, which must accordingly be proportionate in gravity. That the provocation must immediately precede the act means that there should not be any interval of time between the provocation by the offended party and the commission of the crime by the person provoked. The fact that a heated or intense argument preceded the incident is not by itself the sufficient provocation on the part of the offended party, as contemplated by law. The court appreciated the mitigating circumstance of sufficient provocation or threat. In People v. Macaso, a case where the accused police officer shot and killed a motorist for repeatedly taunting him with defiant words, the court appreciated the mitigating circumstance of sufficient provocation or threat on the part of the offended party, immediately preceding the shooting. Extent of provocation to consider as mitigating. When the law speaks of provocation either as a mitigating circumstance or as an essential element of self-defense, the reference is to an unjust or improper conduct of the offended party capable of exciting, inciting, or irritating anyone. It is not enough that the provocative act be unreasonable or annoying. The provocation must be sufficient to excite one to commit the wrongful act and should immediately precede the act. In the instant case, Tumelden's insulting remarks directed at petitioner and uttered immediately before the fist fight constituted sufficient provocation. This is not to mention other irritating statements made by the deceased while they were having beer in Bougainville. Petitioner was the one provoked and challenged to a fist fight. Let us define sufficient and immediate. Sufficient, according to jurisprudence, means adequate to excite a person to commit the crime and must accordingly be proportionate to its gravity. In Bautista versus Court of Appeals, the mitigating circumstance did not apply since it is not enough that the provocating act be unreasonable or annoying. Certainly, calling a person gay, as in this case, is not the sufficient provocation contemplated by law that would lessen the liability of the accused. Definition of immediate. Immediate, on the other hand, means that there is no interval of time between the provocation and the commission of the crime. Hence, in one case, the Supreme Court ruled that provocation occurring more than 1 hour before the stabbing incident is not immediate, and in People versus Benito, 24 hours before the commission of the crime. Per admission of the defense witnesses, the taunting done by the victim occurred days before the stabbing incident. Hence, the immediacy required by law was absent. The lapse of time would have given the accused a chance to contemplate and to recover his serenity enough from pushing through with his evil plan. Thank you for finishing this module. Let's check the next one.